Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. And it is a bad day for Tom Cruise's best friend, David Miscavige. Yikes, you guys. I'm bringing this news to you a little bit late because of all the excitement that was going on here in Clearwater last week. But my goodness, is this some amazing news? A judge has made a preliminary ruling in one of the several lawsuits against Tom Cruise's best friend, David Miscavige. And I'm going to share this with you, and you guys are not going to believe the plot twist at the end of this. So stay tuned. By way of brief introduction, there are three main lawsuits going on right now against Tom Cruise's best friend, David Miscavige. The one that we're talking about today is Jane Doe 1 versus David Miscavige, Religious Technology Center, Bridge Publications, I believe the Church of Scientology International, and Gavin Potter, if I didn't already say his name. Now, in this particular lawsuit, well, as with pretty much every lawsuit against Scientology, Scientology tries to argue that the internal religious arbitration agreements that all members sign over and over and over again prevent Jane Doe from moving forward with this lawsuit. And this ruling from Judge Broadbelt, this preliminary ruling, is the first ruling ever that Scientology's arbitration agreements are unconscionable and therefore unenforceable. This is huge news. And like I said, there's a plot twist here, but let's take a look at this. Now the judge ruled in her favor. I'm going to show you the actual document. I'm going to read you parts out of it. Ruled in her favor on two counts. One, there is a California law that says, it's a relatively recent California law. Arbitration agreements are unenforceable in the cases of SA. Okay, you guys know what that means. If you're YouTube folks, you know what that means. And also that they are unenforceable. Also ruled in her the judge ruled in her favor on that count, and also on the count that they are in fact unconscionable. It's a very specific carve out in the law for unconscionability. So let's take a look at this. As the first part of this ruling, the judge actually acknowledged that Scientology, I'm just going to say Scientology, Tom Cruise's favorite religion, Scientology, is what is meant here by defendants. We can defendant here either refers to Tom Cruise's best friend, David Miscavige, or Tom Cruise's favorite religion, Scientology. Okay, the court does find that Scientology has met their burden to prove the existence of an arbitration agreement and to show that they may enforce the arbitration agreement as third-party beneficiaries of the agreement. So that's just, setting the groundwork there. They have proven that the arbitration agreement does exist, it was signed, and they are able to enforce it short of anything that cancels its basic enforceability. Okay, so let's take a look at this. Validity of the agreement. Plaintiff contends that the arbitration provision in the agreement is invalid as a matter of law. One, pursuant to the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. And two, under the reasoning set forth in McGill versus Citibank. Now, I'm not going to get into all the details on this. He did rule against the argument that it's unenforceable based on the reasoning set forth in McGill versus Citibank. But he did rule in her favor on the first point, and he does rule in her favor later on regarding unconscionability. So let me pick out which paragraph I'm going to share here. Scientology tried to make an argument based on some previous case law that really had to do with a bishop in a church being removed, and the judge basically threw away that argument. Okay, here we go. So EFAA, let me make sure I clearly define what EFAA is. The EFAA is Ending Forced Arbitration of Sexual Assault and Sexual Harassment. That is what is being referred to by EFAA. So the judge's comments on that are, the EFAA, enacted on March 3rd, 2022, voids pre-dispute arbitration clauses in cases involving sexual harassment allegations. Under the EFAA, At the election of the person alleging conduct constituting a sexual harassment dispute or sexual assault dispute, no pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute. I'm going to kind of just fast forward through all the language and the arguments here to the point where the judge rules that this court finds that the sexual assault dispute that is the subject of this action arose on December 29th, 2022, i.e. the date on which plaintiff filed the complaint in this action. The court finds that 2, plaintiff signed the agreement containing the arbitration provision on February 25th, 2002, and therefore it is a pre-dispute arbitration agreement. And 3, the dispute arose after the date that the EFAA was enacted and therefore invalidates the pre-dispute arbitration agreement. Incredible. Absolutely incredible. Okay, the McGill issue, the judge throws out the argument about whatever was going on with the McGill argument. Okay, let's go to the real juicy part here. Unconscionability. Plaintiff further contends that the court cannot enforce the arbitration provision in the agreement because it is unconscionable. As a threshold matter, the court notes that Tom Cruise's favorite religion, Scientology, has argued that the First Amendment bars any unconscionability challenge to the agreement, blah, 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 blah. The judge basically throws away that argument, so we're going to fast forward. Okay. Agreements to arbitrate may be invalidated by generally applicable contract offenses, such as fraud, duress, or unconscionability. The burden of proving unconscionability rests upon the party asserting it. Unconscionability entails the absence of meaningful choice on the part of one of the parties, together with contract terms which are unreasonably favored to the other party. It has both a procedural and a substantive element. Okay, so these are 2 aspects of unconscionability: procedural unconscionability and substantive unconscionability. The former focusing on oppression or surprise due to unequal bargaining power, the latter on overly harsh or one-sided results. As a matter of general contract law, California courts require both procedural and substantive unconscionability to invalidate a contract. Spoiler alert, the judge rules that there are both procedural and substantive unconscionability issues with Scientology's arbitration agreements, and that is why this ruling is incredible. So let's take a look at what the judge says. Procedural unconscionability pertains to the making of the argument. Procedural unconscionability focuses on 2 factors: oppression and surprise. Oppression arises from inequality. Okay, fine. That's actually just repeating what it just said. So okay, let's go. Okay, oppression. Oppression generally takes the form of a contract of adhesion, which, imposed and drafted by the party of superior bargaining strength, relegates to the subscribing party only the opportunity to adhere to the contract or reject. The circumstances relevant to establishing oppression include, but are not limited to: 1, the amount of time the party is given to consider the proposed contract; 2, the amount and type of pressure exerted on the party to sign the proposed contract; 3, the length of the proposed contract and the length and complexity of the challenged provision; 4, the education and experience of the party; and 5, whether the party's review of the proposed contract as aided by an attorney. Plaintiff has submitted in her declaration, in which she states, and I'm going to paraphrase some of this, guys, that 1, officials at the Scientology organization in Clearwater noted that she was not partaking in training. Okay, let me provide a little bit of context here because I'm not sure the judge doesn't explain this. At the time that this arbitration agreement was signed by Jane Doe 1, she was in Clearwater, Florida, at Scientology's Flag land base. They just call it Flag. She was at Flag in Clearwater, Florida as a guest of Lisa Marie Presley. She was not at Flag in Clearwater, Florida to do Scientology. She was just there as a guest. And then all of a sudden, someone realized, no one's allowed to be here without signing this agreement. But usually people sign this agreement when they come here to do Scientology. And Jane Doe 1 sort of arrived here on a loophole because she's just here visiting Lisa Marie Presley. And so she didn't sign the agreement. And some of the Scientology officials at the base were getting in trouble for having Jane Doe 1 on base without having signed the agreement. So that's the context here. Okay, plaintiff has submitted her declaration in which she states that Scientology officials in Clearwater, Florida, noted that she was not partaking in training. Jane Doe 1 was informed that Scientology officials in Clearwater needed to have paperwork showing that she was on the base for a legitimate purpose. The agreement was presented to her for that purpose. She was told that the failure to sign the agreement and other presented documents would result in Jane Doe and Scientology officials getting in trouble. She was told that the documents were meaningless to her, but would allow her to stay at the base. She was not given an opportunity to read the documents. She was not told that the agreement contained an arbitration provision. The court finds that the plaintiff's testimony on these points is credible. The court finds that plaintiff has shown the existence of oppression because she has shown that the agreement was a form contract that was offered to her on a take it or leave it basis and thus was an adhesion contract. 2, she was expressly told by Scientology officials, Tom Cruise's favorite religion, Scientology officials, that failure to sign would get her and other Scientology officials in trouble, and therefore shows that she was subjected to pressure to sign the agreement in order to avoid getting both herself and other officials in trouble. And she was not given the opportunity to review the agreement. The court notes that in reply, Tom Cruise's favorite religion, Scientology, contends that plaintiff's assertion of pressure cannot be used to support a defense to enforcement of an agreement. The court acknowledges that as a general rule, a church is entitled to stop associating with someone who abandons it and is entitled to warn that it will stop associating with members who do not act in accordance with church doctrine. However, even if this conduct is protected, Scientology defendants have not shown that such threats cannot support a finding of oppression based on the exertion of pressure on a party to sign an agreement. Shots fired. The court finds that this evidence establishes a moderate level of procedural unconscionability. Okay, let's look at the other aspect of procedural unconscionability, which is surprise. As discussed above, surprise, actually, I'll just fast forward because the judge rules that surprise was not an issue in unconscionability. So we'll just jump right forward to the substantive unconscionability. All right. Substantive unconscionability pertains to the fairness of an agreement's actual terms and to assessments of whether they are overly harsh or one-sided. A contract term is not substantively unconscionable when it merely gives one side a greater benefit. Rather, the term must be so one-sided as to shock the conscience. The court finds that plaintiff has shown that the arbitration provision set forth in the agreement is unilateral and lacks mutuality. Specifically, the court has identified 4 provisions showing that the arbitration provision in the agreement is not mutual. Guys, this is so incredible that the judge is breaking it out in this level of detail. Like, I've never seen this before. This to me is unprecedented. This is amazing. Okay, first, in paragraph 6, subdivision A, the agreement states that plaintiffs freely given consent to be bound by the rule and law of Scientology means that I, the plaintiff, am forever abandoning, surrendering, waiving, and relinquishing my plaintiff's right to sue or otherwise seek legal recourse with respect to any dispute, claim, or controversy against Tom Cruise's favorite religion, Scientology, and related delineated entities. This provision does not include a mutual obligation stating that Scientology defendants are similarly abandoning, surrendering, waiving, and relinquishing their rights to sue or seek legal recourse against plaintiff in court. I cannot even believe this is the first time a judge is pointing this out, that the agreements Scientology makes its members sign only prevent the individual from being able to sue the organization. It doesn't say anything preventing the organization from being able to sue the individual. And how is it that Scientology, hasn't changed their agreement? So these agreements have been being signed for like 20, 25 years now. It seems like at some point they would have been like, oh shit, these things aren't going to hold up unless there's some mutuality there. But, I guess they get away with whatever they can get away with for as long as they think they can get away with it. Okay, let's keep going. Second, in paragraph 6, subdivision C, the agreement states that Should I or anyone acting or purporting to be acting on my behalf ever sue or otherwise seek legal recourse with respect to any dispute, claim, or controversy against any Scientology church or related entities as set forth in the agreement, I intend for the submission of this contract to the presiding judicial officer to be a complete and sufficient basis for the immediate dismissal of any and all such proceedings with prejudice to further proceedings of any kind. This provision, 1, applies only to the initiation of a lawsuit by plaintiff or anyone acting on her behalf. And it does not permit plaintiff, if Scientology were to file a lawsuit against her, to use the agreement to dismiss such proceedings. Oopsies. Third, in paragraph 6, subdivision D, the agreement further explains that should any dispute, claim, or controversy arise between the parties, I, plaintiff, will pursue resolution of that dispute, claim, or controversy solely and exclusively through Scientology's internal procedures. This provision also obligates only the plaintiff. It does not obligate the defendants. Fourth, the language set forth in paragraph 6, subdivision E, further shows that plaintiff was the only party obligated to submit claims to arbitration. For example, in describing the arbitration procedure, the agreement sets forth the following language: I will submit a request for the arbitration to Scientology's international justice chief. In my request for arbitration, I will designate one arbitrator. And consistent with my intention that the arbitration be conducted, emphasis was added by the judge. The language used in describing the arbitration procedure, again, contemplates that the obligation to submit any arising claims or disputes to arbitration applies only to the plaintiff and therefore is not bilateral. Finally, the court notes that Scientology defendants contend that plaintiff's statement that she agrees to arbitration of disputes creates a mutual obligation. The court disagrees. The court acknowledges that there are cases the court acknowledges that there are cases declining to find that the mere inclusion of the words "I agree" by one party in an otherwise mutual arbitration provision destroys the bilateral nature of the agreement. However, as set forth above, the arbitration provision in the agreement here includes various terms establishing that the obligation to submit claims to arbitration is binding only on the plaintiff and therefore is not an otherwise mutual arbitration provision within the meaning of those cases. The court finds that plaintiff has established a high level of substantive unconscionability by showing that the arbitration provision set forth in the agreement lacks mutuality and is so one-sided as to shock the conscience. That is incredible. Thus, because plaintiff has established a moderate level of procedural unconscionability and a high level of substantive unconscionability, the court finds that the plaintiff has met her burden to show that the arbitration agreement is unconscionable and therefore unenforceable. Guys, this is utterly devastating to Scientology. Okay, a little more here before I give you the plot twist. Conclusion: for the reasons set forth above, the court finds that Scientology has met their burden to show the existence of an agreement to arbitrate this controversy, and plaintiff has met her burden to show that Scientology cannot enforce the arbitration provision against her because it is void under the EFAA and because it is unconscionable and therefore unenforceable under California law. The court therefore denies defendant's motion to compel arbitration. Holy shit. So here comes the plot twist. This was published as a preliminary ruling, a tentative ruling. Everyone showed up for the hearing. So what happens? The judge publishes a tentative ruling. The parties show up the next day or the day after, and they make, since they already know what the judge is thinking, they show up prepared to make their best arguments before the judge makes his final ruling. Scientology, Tom Cruise's favorite religion, Scientology, knew damn well they were not going to change this judge's mind. So they took the nuclear option. They showed up to the hearing and filed a peremptory challenge saying the judge was incapable of being fair and demanded that the judge be removed. And the judge was removed before this ruling was issued and became official. This is going to backfire on Scientology. And in order to explain some of the next steps here, I have to give you a little bit of information about the two other lawsuits again that pending currently against Tom Cruise's best friend, David Miscavige, and Tom Cruise's favorite religion, Scientology. So the same Jane Doe who has filed the lawsuit we've just been discussing is also a party to another lawsuit called Bixler versus David Miscavige, Scientology, Danny Masterson, et al. That's one of the other lawsuits. Leah Remini is also presently suing Tom Cruise's best friend, David Miscavige, and Tom Cruise's favorite religion, Scientology, for harassment, stalking, tortious interference, intentional infliction of emotional distress, all sorts of things. Okay. Let me try to connect all these dots. I've got some notes here. I did prepare before, but I've got to refamiliarize myself with some aspects of this. Okay. The judge who issued the tentative ruling that we just discussed, that was Judge Robert Broadbelt. He's the one that Scientology showed up and said, we don't like you. We want a new judge. And procedurally speaking, they were justified in making that request. They knew that request had to be honored. And Judge Broadbelt was replaced. The new judge that has already been assigned to this case that we've been discussing is Judge Michael Small. This is where things get crazy. In the Bixler lawsuit, by the way, the Bixler lawsuit is this is the lawsuit brought by Danny Masterson's victims and some other parties, including some spouses of the victims. And the lawsuit is for harassment, stalking, intimidation, fair game. And in that lawsuit, it was originally being overseen by, I want to get a Judge Kleifeld. And the case was already underway for like over a year or two when Judge Kleifeld retired. And guess who was assigned to that case? Judge Michael Small. And in that case, one of the parties of one of the plaintiffs also filed a peremptory challenge against Judge Michael Small and had him removed from that case. Now, it's not because anyone thought he was incapable of being fair. It's because Judge Michael Small has never really overseen, and I want to get my language on this right, so give me a moment here. He's basically a probate judge. He's never overseen complicated civil litigation, the type of which these Scientology cases are. And the plaintiffs were concerned that Scientology was that Judge Small was out of his depth. He was in over his head in this type of litigation, and Scientology was going to be able to roll right over him. So they made a peremptory challenge in that case. They got rid of Judge Michael Small, and they were then assigned, I want to get this right. I want to say his name correctly. Judge, I'm going to pronounce it Upinder Kalra. It's Upinder. So I'm not sure if it's Upinder or Upinder, but it's Upinder Kalra. And as of right now, everyone seems to be happy with Judge Kalra. And so let's see. Recently, in Leah Remini's lawsuit against Tom Cruise's best friend, David Miscavige, that judge was also issuing rulings that Scientology and David Miscavige did not like. And they just recently filed a peremptory challenge against that judge. They also showed up to court with that judge and said, we don't like this judge. We want a new one. And so then that judge was taken off that case. The judge that was assigned to Leah Remini's case is a judge named Holly Fuji. Now, Holly Fuji has a nickname that the lawyers who prosecute in her courtroom and her courthouse, she has a nickname. It's Satan. Judge Holly Fuji is known to be anti-plaintiff. Not an excellent judge for Leah Remini's case. Leah Remini is currently asking to have her case also assigned to Judge Upinder Kalra. Well, That is also what's happening in the Jane Doe versus David Miscavige and Scientology lawsuit that we just discussed. Her team is also asking now for Judge Small to be removed once again from another Scientology case and asking for this lawsuit to be assigned to Judge Kalra. Everyone just wants Judge Kalra. Judge Kalra could wind up with 3 separate civil lawsuits against Tom Cruise's best friend, David Miscavige. Now, here's the thing. When Jane Doe, Jane Doe in this lawsuit is also, it's okay for us to say this, it's okay for this to be known, is also Jane Doe 1 in the Danny Masterson case. So Jane Doe 1 in the Danny Masterson case is also one of the Jane Does in the Bixler versus Scientology lawsuit, and is also the Jane Doe in this lawsuit against David Miscavige. And she's been busy. When she filed this present lawsuit that we've been discussing against David Miscavige, she was already part of the existing Bixler lawsuit, and that lawsuit was already with Judge Kalra. So when she filed her lawsuit, she specifically said, there's something called a related case argument. She specifically said, hey, I have a related case currently pending under Judge Kalra for everyone's benefit, our benefit, the court's benefit. Please put these cases under the same judge. She already made that argument when she filed her case. So her team right now, my understanding is that her team is not yet using their peremptory challenge against Judge Michael Small. They are just using the related case argument to move the case over to Judge Kalra. I think we can expect that if that argument fails, her team will use her peremptory challenge to say Judge Small's got to go, and then make an argument, please honor my previous request to put this with Judge Kalra. So here's the other thing. I have it on the good authority of people who are actually legal experts, which is not me. These judges all work together. These judges are all, maybe they're not all friends, but they're respected coworkers and associates. They don't take kindly to these kinds of shenanigans. I'm told there is a very high likelihood that the next judge will simply adopt Judge Broadbelt's tentative ruling that was already published. And because he already published it, the other judges will know his tentative ruling is the reason Scientology tried to get him removed. And that's not exactly the way the law is supposed to work. You cannot, Scientology, just as a matter of procedure, had a right to file a peremptory challenge. But just because a judge is ruling against you in a particular way doesn't make the judge unfair. And a new judge coming in is going to look at the tentative ruling and likely go, sounds right to me. They're not going to reinvent the wheel. They're not going to re-argue the entire thing. They're not going to, start all over. So basically, Scientology just used up its only peremptory challenge, is my understanding. And I just cannot tell you how excited I am and how important it will be for the entire landscape of litigating against Scientology to have an official ruling made that these contracts are unconscionable, and have it broken down in such excellent detail as Judge Broadbelt did. There you go, guys. That is what we have to report. I have one of my amazing moderators, SPTV Tattoo Warrior, in the back office, starring some comments from me. So let me run through some of these, and then we'll call it a wrap on this one. I got to go pick up my daughter from school anyway, so this is perfect timing. All right, Linda Perales. Hello, Aaron. East Hemet here. Hello, Linda. Go say hello to everybody over at Scientology's Int base for me. Oh, Kay says 11th Circuit Court in Florida earlier this month ruled that the trafficking suit requesting appeal be denied. So this is so incredible. I'm glad you mentioned that. That is yet another one of the lawsuits that I, because I was, because I was so busy in Clearwater this past week, haven't done my update for. It's true. One of the other lawsuits against David Miscavige by 3 Australian former Sea Org members was ordered into arbitration. It had already been ordered into arbitration, but that was on appeal, and the appeals court came back and said, no, your appeal is denied, or we're either not going to hear your request for an appeal is denied. you have to go to arbitration. So that one looks like it might be dead and buried. We'll have to see what happens there. And I will do an update on that as well. C.K. Rardin, if Scientology is indeed a religion, I've never heard of arbitration being a part of any religion. So is Scientology arbitration agreement part of employment or a requirement of being a parishioner? C.K., it's actually both. Regular public Scientologists, you might call them parishioners. They're the ones who pay to do Scientology. They don't technically work for Scientology. Public members and staff members and Sea Org members all sign these arbitration agreements over and over and over and over again. And I simply don't have any knowledge of what the prevalence is of these agreements in other so-called religious organizations. I just don't. I'm guessing most Christian, Jewish, Muslim organizations don't have you sign arbitration agreements when you join up. But what do I know? The only cult I grew up in was Scientology. Lydia Von Stretchclaw, one of my amazing moderators, about time they see that Scientology arbitration is actually just a kangaroo court. Absolutely. Anna says, isn't this made void by the fact that they changed judges? Good question. I addressed that just a moment ago. Will this help Leah's case in any way? No, Leah's case was actually not subject to arbitration because what Leah was suing for were things that all happened after Leah left Scientology. And, oh, timer's going off. And so Scientology didn't even try to force Leah's case into arbitration. So it's totally irrelevant. Okay, I'm going to fast forward through some of these here. Gone with the gale. The important thing about the lawsuits is that they get public attention and that the public looks into what Scientology is. Makes protest even more important. Good point. I appreciate that. All right, let's see here. I'm going to skip some of these. Okay. More to me. I started watching after my work took me to the Gold Base and to Twin Peaks. Wow. I had no clue what they were. Love the channel. Love your work. Wow. More to me. Shoot me an email. I'd love to hear what your work was that you went to both Gold Base. Because the Gold Base, I mean, well, the Int Base you're talking about, talking about the base where Golden Era Productions exists, the International Management Base in Riverside County, California, outside of Hemet. The fact that you went to the Int base and to the CST base out in Twin Peaks, that's crazy. Shoot me an email, growingupinscientology@gmail.com. I'd love to hear what you were doing if you want to talk about it. Okay, let's see. Smooth Steve, SPTV in NYC. Just because Scientology can do it legally doesn't mean it helps them in the long run. And you're right. These judges don't like people messing with the legal system at all. Thank you for that. Ginger, oh snap. If they're all tried by the same judge, even though 3 separate cases, could Scientology try to take it to the Supreme Court appeal for anything? I don't know enough about the law. Thank you for the question. Obviously, I'm no expert in the law as well, but I just can tell you from precedent, Scientology will take anything to the Supreme Court that it possibly can. I do not like this related case argument is something. It's an actual legitimate argument that's meant to create efficiencies in the legal system. I'm going to guess, you guys, it's common sense, really. I'm going to guess that cases being grouped under a judge under the related case argument, I'm guessing by itself cannot be a point of appeal. But what do I know, guys? I'm no freaking lawyer. Okay. Let's see. Funny Hat Blue, are you truly coming to Montreal in a few weeks' time? Yes, I will be. I'll be in Montreal for either 2 days or 2 nights sometime in the middle of next month. I'll try to give you guys some advance notice. Maybe we can meet up at the Montreal org and see what that absolute dumpster fire looks like. Cool, guys. I got a jet real quick, but I'll be back soon. Much more to come this afternoon. Thank you, everyone, for hanging out with me. Thank you, as always, to everyone who watches until the very end. Hit that like button. Talk to you guys soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.